Hello everyone, welcome back to the video updates. Today's question came from an asset locator that works on excess proceeds or surplus funds, helping claimants to claim those excess funds. And the question was in regards to finding out that the potential claimant's name was in the court case. This was a tax foreclosure sale. And so the case was filed in a court, so it was not a non-judicial foreclosure, it was a judicial type of a foreclosure. So the claimant's name was in the case record, and the locator was confused because there were different names in the case record from two different families. And so the locator wanted to know, is this claimant actually somebody that might be entitled to those excess proceeds, or is the other claimant or the other claimant that have a totally different name, are those the people that are entitled to the excess proceeds? And this tends to come up a lot from the foreclosures where the title is not 100% clear. So there's always a title search done by the county's attorneys. When it's a mortgage foreclosure, it's more ascertainable who actually is on title, because the mortgage lenders always have a deed of trust or some sort of security instrument that shows who took out the loan. And also then there's a deed, which is typically a warranty deed of some sort, or that has to do with title. So remember, the loan is sometimes separate from the title. But if you follow the warranty deed or whatever deeds transfer title, and there is a chain of title in the property records, you can tell who owned that property right up to the date of the foreclosure sale. Sometimes you cannot tell because some documents were either misfiled, or some documents were filed inappropriately, or the documents filed were not drafted clearly enough, and there's ambiguity as to what the document was actually trying to do, what was the intent of the parties at the time that it was filed. And then in some scenarios, which is what happened in this particular case, the property itself was from a long time ago as far as the origination of the deed, the original deed. But sometimes it's just the fact that the original deed that conveyed title to the very first owner of that property is from a long time ago, and then the subsequent transfers were done in a different way, because back in the olden days, the laws were not as strict as to how the documents were to be recorded, or whether they were to be recorded at all. So in a lot of states, including Texas, the laws changed recently. For instance, in Texas, any deeds that were done, like a contract for deed, for instance, that like an agreement for me to sell to you, as long as you pay me over time, and as soon as you make the final payment, I'm supposed to sign over the deed to you, that's called a contract for deed. And they call it by different names, but typically it's a contract for deed, or you can call it an agreement for deed. And a lot of times those things never got filed back in the olden days. People just signed at the kitchen table and shook hands, and somebody started making payments every month, and sometimes they never got the final document filed. So in Texas, for instance, before 1995, the law did not even require people to file those contracts for deed. And so a lot of things might have happened and fallen through the cracks because the parties forgot to come back and file the final document, the most important document, to show that party B paid all of the payments that they were supposed to make to party A, the original owner. So those things cause a lot of problems in the chain of title, because eventually what happens is party A got all those payments, is now deceased, and party B made all those payments but doesn't have clear title to show. That doesn't have any title at all sometimes. All they have is possession of the land. And then they go ahead and pass on the land to their descendants or to a third-party buyer and sign over documents. Informally, mind you, because if they went through a title company, the title company would have noticed the discrepancies and the break in chain of title and would have demanded that they fix it. All of this just to let you know that it's not always very clear who is entitled to the excess proceeds, because remember, the owner as of the time of the sale is the one that will be entitled to the excess proceeds, and we have to determine who that would be. So in the scenario that I just described to you, party A's descendants will be named in the lawsuit because that's the party that was on the title inside the property records, and party B, who mistakenly thought, oh, I owned the property because I've been using it for years and years and years, and is now deceased, the descendants of party B will also be named in that lawsuit because the county's attorneys, they can tell that something is not quite right, usually because the title documents show party A, but the tax payments are showing party B's name for years and years. So in order for them to be on the safe side, they list everybody in the lawsuit. And so you'll see, descendants of Smith and then descendants of Jones, for example. And then you'll have to figure out, well, who owns the right to the excess proceeds, because it's confusing, right? So the lawyer is the only one that can then go back into the case records and research also the property records and see if there's a way to prove up that party B's descendants are actually the ones entitled to those funds. And hopefully the lawyer knows how to do this, because there are many different ways to do it. The right way to have done it would have been to do it before the parties died or before the foreclosure happened in the first place. But most of these people don't even know, because they assume that they have title because they've been using it without interruption and without anybody coming to confront them about it for years and years. And so they assume that it belongs to their family. And this is the first time they're probably finding out that the name on the official title records is not their family name. It's a whole different family that owned the property prior. So the right way to have handled it would have been to address this issue in the break of title or in the lack of transfer, proper transfer before the parties died, or at the very least before the foreclosure sale happened. So the ways that the attorneys tend to handle this is either just, if the people are still alive, get the deed from party A to party B. The party A will sign it saying, oh yeah, we agree to that, we just never finalized it. If they're already deceased, the descendants might be problematic because people get greedy, right? Once they see that they have a chance to go and reclaim property that their ancestors owned, sometimes people get really greedy and they don't cooperate. So then what will the lawyer do in that case? The lawyer would probably file a quiet title action, or what we call trespass to title action. So quiet title action or trespass to title action. And those two are slightly different in the state of Texas. I'm not sure about other states. And the main goal of either action is to try to show that title is in you, the plaintiff. So let's say I filed the quiet title action. I'm trying to get the judge to declare that I'm the owner of that property. I'm trying to get the court to declare that I'm the only owner of that property, or that myself and a couple other people that I've listed are the owners of that property, that the defendant is not the owner of that property, and that I have clear title now. So that's the sole purpose of the quiet title action. The trespass to title action is slightly different, but it also, if you can hear it, it's almost like saying somebody's trespassing on your title. So it's also going to get you to the same end goal if it's filed that way, okay? So lawyers can file those two things, and sometimes if the way that the property was acquired was not through a contract for deed, but because the person took over and that original owner never came back to claim it, then you can do, of course, an adverse possession action, which is very different from the quiet title action. Adverse possession can be used even if I never had a contract with the original owner, or I never had any real rights to the property other than the fact that I took over all the payments on it, all the maintenance on it, and it's been a lot of years. So each state has different laws about how you can go about doing that. The lawyers that are real estate lawyers can help you with those things. The real estate lawyers can usually figure this out if they also do litigation, because they know how to clear title. And this is, of course, only useful if the foreclosure hasn't yet happened, right? Because you cannot do all these actions when the property is now already been foreclosed upon. So all of this to say that if you're watching this video and you're having chain of title issues, or if you're not sure if property is in your family's name when it's supposed to be, make sure to check do a consultation with a real estate lawyer, and they'll be able to tell you if there's clear title that's showing your name or your family's name as opposed to some other people's names. Okay, so make sure to check into that, because the best time to know that is before you have to sell the property or before you have to start trying to claim excess proceeds following a foreclosure. You do want to know that, and you want to correct it as soon as possible. So with all that being said, if the lawyers had done that prior to the foreclosure sale happening, then they get a court order, like I said, and that court order is what you will then use if a foreclosure ever happened. That court order from the quiet title action or the trespass to title action or the adverse possession action, that would be sufficient to show to the tax lawsuit judge that you actually would be entitled to those funds, because the order shows that your family was the true owner of that property. So this is just me giving you a rundown. All of these things are quite complex, and it takes sometimes years to litigate those types of cases, but it's worth it if the property is worth quite a bit of money, right? And in this particular case that I got, the excess proceeds were about $44,000. It's not a ton of money, but it's enough money for people to really want to assert their rights. So so those are the things that will be done, and that's why sometimes you find conflicting lists of claimants, because it's not 100% clear. And even though you can find some deeds in the property records, it's confusing sometimes because you're not clear on who really owned it, and why is this tax foreclosure case listing all these different parties that don't seem like they should have any right to those excess proceeds. So typically that's what it is that there was no clear title shown in the property records. If there's clear title shown in the property records, then the tax office's attorneys or the county's attorneys, they can quickly figure that out, and they'll list only that party or only those parties as the defendants. And then you'll be able to quickly skip trace, find those people, and then it will be an easier case. Now, let's say there was a court order in the past for quiet title or something like that, and the county's lawyers just happen to miss that. Then your lawyer that's helping you claim the excess proceeds, or the lawyer that's helping the claimant claim the excess proceeds, they'll be able to do research. They should be doing this type of research in order to find something to justify that that particular claimant is the one that's entitled to the excess proceeds. And sometimes we've had some like this where there was no quiet title action done, there was no adverse possession action done, nothing was done by the parties. They just kept living on the land, passing it on to their descendants. And so when we got into that kind of a scenario, we had to put together an affidavit. We had to put together an affidavit of claim to land, which is typically what people do prior to filing an adverse possession action. And then they go ahead and file an adverse possession action to get an official court order. But because it was already too late to do all of that, I went ahead and had the claimants who were the grandchildren of the original owner, who we claimed to be the original owner but was not on title officially. So we had put together an affidavit of claim to land to explain, basically, to swear to the truth of the fact that their family had always cultivated that land, owned it, maintained it, paid all the taxes on it for over 40 years. Now, the law doesn't require you to do it for over 40 years in order to get adverse possession, but it was very, very persuasive for the court to see that affidavit, and the judge agreed with us and released those funds to my claimants, who were actually the grandchildren of the deceased person who was on the land but never had clear title, never got the title. So anyway, the questions you'll be asking when you come across something like this is asking yourself, well, is it worth pursuing this particular claimant? So what does this video mean to you as a potential claimant or as an asset locator? The video is just trying to explain to you that sometimes there are complexities there. It's still worth having the attorney that's going to be helping you claim the excess proceeds to look into it further. So even if the attorney first says, well, I see that your family's names are in the court case, but I don't see any warranty deed or any kind of quitclaim deed transferring that property to your family, you can let that attorney know that your family has actually been in possession of the land for years and years and years. So that could change the attorney's analysis of the case, and the attorney might be willing to fight for you to be able to get those funds. And there might actually be a way to do that. And you can also, of course, tell the attorney to please research that you might not know of any lawsuit that happened between the parties, but for the attorney to please research to see if there was any quiet title action done at some point in the past. And because that will be helpful to your case. So I hope this video has been helpful to you. Don't give up just because you see that they're weird, claimants on both sides and the names are completely different. They're not related at all. Just pick one claimant to go after. And if you can find a deed that's closest to the date of the foreclosure, an actual like a warranty deed or a special warranty deed or some sort of quitclaim deed, you might be better off pursuing that particular type of claimants because they have the most recent deed of title showing title in them or their ancestors. So that would be the better claimant to go after rather than going after the one that's very, very complex or difficult to prove up. Obviously, you go for the low-hanging fruit and hopefully they're the right ones. And if they're not the right ones, you just move on and help somebody else because there are tons and tons of claims out there still waiting and lots of people out there still waiting to be helped. So I hope this video has been helpful to you as always. Thank you for watching. And I meant to add, if you've not yet subscribed to our channel, please do so. It's encouraging for me to see all the new subscribers. And of course, if you like the video, remember to click like. And I hope you have a wonderful weekend and I'll talk to you next time.